Breaking news from the Supreme Court on gay marriage. NBC News Justice correspondent Pete Williams is on the phone from inside the Supreme Court. Pete?
Well, Susan, this is a surprise. The Supreme Court has waded with both feet into the issue of gay marriage. As widely expected, they agreed to take up a challenge to the Federal Defense of Marriage Act, which is the federal law that says the federal government cannot recognize same-sex marriages even in the states where they're legal. But, and I think this is the surprising part, the justices also agreed to take up a challenge to California's Proposition 8, which could either be a very narrow decision about California only, or the justices could take up the basic question about whether states can deny same-sex couples the ability to get married. These cases won't be argued until probably March, but I think it's very surprising. This is a huge action by the Supreme Court today, wading fully into the issue of same-sex marriage. So it's going to mean that this will be an absolute blockbuster term.
Pete, can you talk a little bit about what it means to take two cases in this way at the same time? And we know from the ACA decision that Justice Roberts cares deeply about his legacy and the legacy of the court. How do we read that into this discussion? Is he going to want to be part of a decision that is stripping rights away from people, and then he looks into the future and he's in one of these cases like Plessy versus Ferguson, where people are looking back and saying he was the Chief Justice when they took rights away from millions of Americans?
We can read nothing into any specific justices thinking about the fact that they took up the Defense of Marriage Act. I think that was a foregone conclusion. Whenever you have federal courts, as has happened here, striking down an act of Congress saying it's unconstitutional, the fact the Supreme Court would agree to hear that case, I think, was a given. The surprise here is that they've agreed to take the DOMA case, or the Prop 8 case from California, because I think it's believed among some folks following this case that, look at it this way, if you're conservative members of the court and you believe that this case is wrongly decided, remember the appeals court decision below said that Prop 8 was unconstitutional. That's the proposition passed in California in 2008 that barred same-sex marriage after they had already started there. If you're a conservative and you think that case is wrongly decided, I would be surprised if you would vote to grant that case unless you thought that the appeals court was wrong. That would indicate that the conservatives must think that they have a fifth vote here. Remember, it takes only 4 votes to grant a case, but 5 votes to win. And generally, you don't want to grant a case unless you think your side has a good chance of winning. So I can't read into any of this what an individual justice may be thinking, but I think the surprise there is Prop 8.
Yeah, well, Pete, obviously there's really no track record here for the Supreme Court in dealing with gay marriage cases. There is a bit of a track record for the Supreme Court and some of the current justices in dealing with issues about gay rights. You had the Texas case in 2003. Could even go back to 1986 if I'm remembering right. Scalia was on the bench then, maybe not. But I wonder if there's anything in the specifically the Republican appointees' histories in dealing with gay rights on the bench that's relevant to sort of be thinking about right now in terms of how they might approach these cases.
Yes, and the key is Anthony Kennedy, because he's the one who's written the 2 most important gay rights issues, one dealing with an amendment in Colorado, the other the Lawrence v. Texas sodomy case. He's been the critical vote. He's the author of those opinions. He's going to be the critical vote in both these cases, a Republican appointee of Ronald Reagan. So his vote is the essential one, I would say, in these cases. And I think that was the gamble all along in getting the Prop 8 case to the Supreme Court, is that they could get Anthony Kennedy. Well, now we're about to find out.
Pete, could you sort of take us inside? I mean, how do they decide which cases they want to take up?
The Supreme Court gets about 10,000 cases a year, of which they'll hear argument in about 75 or so this term. And basically any justice can put on the discussion list any of those cases that justice thinks should be granted or taken up. They have a list for every one of their private conferences. This is the second time these cases have been on their conferences. We thought we were going to go through this all last Friday, if you recall,
right,
but they didn't act on it. So it only takes 4 of the justices in their private conference to grant a case, and we don't know, of course, when these lists come out, how many justices voted or how they voted. We just know that they got at least 4 votes to grant these cases.
So Pete, to sort of go back to what you were talking about before in their decision to take up the Prop 8 case, I mean, it sounds like what you're reading into that is if you're someone like me who wants to see same-sex marriage rights extended, that you might be a little bit dismayed by the fact that they decided to take this case up. Is that accurate?
Well, that is an issue that has divided the gay rights community because there were many people who thought this was the wrong thing to do, but the lawyers who got this case to the Supreme Court, Ted Olson and David Boies, with the backing of Chad Griffin, who's now running the Human Rights Campaign, the pro-gay rights group, they thought this was the time to get this to the Supreme Court, that they believe history's on their side, that the tide of history is moving in their direction. But it's a gamble. It just, I think it's all going to come down to Justice Kennedy. I mean, that's everybody's assumption. You're right that the Supreme Court has never directly confronted this issue. There was a 1972 case where the Supreme Court was asked to rule on gay marriage law in Minnesota, and they basically said there's no substantial federal question there. It's not for us, and kicked it out. But that wasn't a very heavy intellectual lifting there. This is the first time they will ever confront this case directly for this issue.
Pete, last time we saw a highly controversial case in Obamacare, we saw a full court press to really lobby these justices and to put a lot of pressure on them, recognizing that they will set the tone of what this court looks like. Do you think that we're going to see that hard lobbying again?
Well, I don't think it'll be quite like that because there isn't as much money at stake as there was in Obamacare. But obviously, to many people on both sides of this issue, it's an important values question. It'll obviously attract lots and lots of friend of court briefs. Remember that only 9 states have chosen to make same-sex marriage legal, and many other states, the majority of states in the U.S., have decided not to allow it or have amended their constitutions to forbid it. So there are strongly held views out there, and yes, I'm sure that the justices are all about that by the time they get ready to hear this case argued in March.
So might we end up with a situation where in every state in America you can or cannot get married, and this will just decide this, at least for the time being?
Well, that's the interesting question here. We don't know. The DOMA case doesn't invite the court to answer that question. It simply says, if in those states that decide to grant same-sex marriage, which is up to the states, can the federal government still refuse to recognize those marriage? Even if the Supreme Court strikes down the DOMA law, it won't say anything about whether a state has to allow gay same-sex marriage. Now, on the Prop 8 case, it is possible to rule on that case very narrowly or very broadly. Let me explain. When the Court of Appeals said that Prop 8 was unconstitutional, it said you can't do what California did. You can't give the right, which the California Supreme Court did, and then take it away, which Prop 8 did. California is the only state that did that. If the Supreme Court merely upholds the Court of Appeals ruling, that ruling would be good for California only. But if the Supreme Court dives fully into this and gets into the basic constitutional question about whether states can block same-sex marriage, then yes, they would get to it. But they won't. The mere fact that they've taken up the case, we don't know whether they'll go that far.